Hi, welcome back to CS 170. A couple of clarifications before we kick off with the lecture. So one of them is around the Excel pivot table assignment. So you have this right here where it says enter the customer with the most orders based on a distinct row ID from the filtered set. Um, so people have some questions on that, so let me just clarify. You see this column here? This is row, this is the order ID or the row ID, I should say, here. All right, so you can see, let's say this order here, right? So this order all the way down here is all the same order, but they've kind of broken up into these distinct row IDs, right? Uh, so, you know, it's basically these, it's just, they're just breaking up into different categories under the same order, okay? Um, that's why they have the same order ID, right? But it's basically broken out into these distinct groupings here. So you can almost say like what the question is asking for is kind of like the number of different products that are being ordered. And so once you do a filter, right, so you're supposed to be doing a filter based on the, I believe it's the segment and the city, right? Philadelphia and New York. Once you do that, it's only going to be like maybe a dozen records or so, 15 records maybe. And within that, you should see one customer that stands out very clearly that has a larger number of row IDs compared to the other customers. There's only going to be a few customers. Um, so there's no formula to figure this out. Once you do the filters, there's only going to be like, like I said, maybe 15 records or so. It'll be very clear which customer it is. And you'll just put that answer down here in cell A307. Okay, so hopefully that clarifies that question. Okay, so it's not meant to be a hard question. It's meant to be a fairly straightforward question to answer once you apply your filters to it. Okay, so let me close this up here. Close this up here, and I'm going to come back to assignments here. The other question that people had was about our assignments were asynchronous lectures and recitations. So what that means is I've asked the TAs to make sure they put announcements out there, which I believe they have been putting announcements out there to record whatever videos they need to support the recitation project. Um, and we're going to be due with the recitation projects at the Thursday night, and the latest you can turn in, for partial credit will be on Sunday. Uh, oops, let me actually go back to here. It's going very slow here. Okay, so you can see like Harsh has already put out a couple here. This is for section 18 and 20. Uh, this is for 35 and 36, 17 and 19. So you can see some of the announcements are starting to come through for particular sections already. Um, section 7 and 8, and here this is my announcement on the recitation project. And so you can see here, we opened it up on Monday. You have the due date for Thursday night. You have accept until Sunday. Okay, so that's the recitation project. And if you go back to modules, you can look up everyone's lab hours. So just like it has been, all of the lab hours are open to everybody. So whoever wants to pop into the lab hours, they can do that. So you can see that here. Let me zoom in a little bit. So any of these hours here, you can just pop into these WebExes. If you want to pop in with me, you can just make a reservation with me. Just let me know, send me an email, and we'll schedule a time appropriate for the practice for the exam, or answer any questions for the exam. Same thing, you can pop in here, get some help with that. Of course, you can also reach out to your TA, schedule some time with them. I would suggest to kind of give them a first shot to review whatever questions you have. If you still have open questions after that, drop me a line. I'll try to respond through email, or we can schedule a time to go over your questions to prepare for the final exam. Okay. All right. So with that, let me go back over to here. And so there were some questions about like how the chatbot, how does that relate to the filter bubble? And I think the analogy I was just trying to make there is that just like a filter bubble, the type of information that you feed in will tend to kind of feed upon itself and continue to, if you're particularly biased or focused on one particular view, it'll just keep on reinforcing that view, right? There's no correcting mechanism, or there's no balancing mechanism, right? So the filter bubble tends to keep on reinforcing, right? So it looks at what you like to read, and then keeps on feeding you more of what you like to read, which only tends to reinforce that view, and it continues to build on itself. In the same way with the chatbot, how it was being trained by just releasing it into the wild and just interacting with whatever it found out in the internet, also follows along similar lines. So that's what I meant by that analogy. Okay. Let me see here. Passwords we did. Let me get down here a little bit. The phishing attack we did. Okay, so the next section here we're talking about is intellectual property, protecting intellectual property. And so there's different types of information that we're talking about here. And so there's like the information itself. There's like what we'll call just software products, right? So I'll get into that in a second. And just all kinds of like material that's out on the web, right? Could be music, it could be pictures, movies, whatever, right? There's all kinds of stuff out there, okay? So when you look at the software licensing agreement, I know a lot of times people look at these things and they don't really look at it. It's like pages and pages of stuff, right? But if you look closely, the idea really is that you didn't actually purchase or own that software. It's not like you bought the source code for this software that you have, or the application, such that you can go and change it, you can copy it, you can resell it or whatever. You really can't do that if you really look closely at the software license agreement. Some license agreement obviously goes way further than that, but that's the general idea with the software license agreement. Okay, so you have these terms and conditions, which basically involves preventing you from taking it, turning around, selling it, or copying it, distributing it illegally, or modifying it and then turning around and selling it, whatever. Like all of that type of stuff is protected under the software license agreement. Okay, I think, yeah, and let me just mention this part right away. So that's why the idea is that you didn't actually buy the software, you actually leased the software. So you bought the right to use the software, but you don't actually own it, right? So that's basically the company that sold it to you. And I think one thing that kind of plays into like where the technology is evolving to is this idea of software as a service. So back in the old days, a lot of times you're just like taking the application, downloading a copy, or you're getting a disk or something that you have a local copy of that software, and then people will go around and try to make copies of that and do whatever to it. So it's kind of sitting locally with you, right? But now with software as a service, which I know it's not highlighting the slide here, but software as a service, basically everything's like in the cloud, right? You don't actually download much onto your computer. It's something very thin that loads onto your computer. And so all of the guts, like all of the brains, the logic or whatever, it's mostly sitting away from you. You don't actually have a local copy of it. It's not generally accessible to you, okay? I know that's not 100% true, but that's generally true when you're talking about software as a service. So uh, and that's why you get into things like Microsoft Office, right? So you have like in the old days, you would have copies of Microsoft Office, like everything, sitting locally on your computer every time you got updates and whatever. But now when you have 365, everything is basically hosted on the cloud, and you're accessing it through your browser, maybe, right? I know you also can get a local version of it too, but generally, everything is out on the cloud. Okay, so you want to store stuff, it's going to be stored out on the cloud. It's not going to be stored locally. You could store a local version of the data, your data, presumably, but the actual software, it's going to be sitting out on the cloud, the brains of it. And you know, there's always going to be, you're always going to be assured, or should be assured, that you're going to be getting the latest copy. So let's say they found a bug, or however many bugs, or they enhanced it, whatever. So instead of waiting every couple of years for a new version of Microsoft Office, let's say, they'll continually be releasing new versions of it, and you'll just pick it up automatically, because it's not really hosted on your computer per se. Um, and so in exchange for that, you're going to be paying money for it every year, right? That's why it's sort of like a software as a service type of thing, as opposed to I go down to the store, buy a copy, bring it home to my computer, and install it. So where the intellectual property is going kind of lines up to this fairly well, right? So the idea that your software is not something you purchase, but you lease it essentially, or you buy it as a service, and you renew it every year or whatever the period is. Okay, so that's the idea behind how we look at intellectual property from a software standpoint. Okay, um, this part, the lease part, is important, right? And like I said, with the current technology, it kind of fits in well with that, where software as a service is going. Now, there's other ideas about open source software. Um, So if I have my own company, I'm Microsoft or whatever, I write my own custom software and I sell it to people. Uh, that's what they would call proprietary software, right? So open source software is sort of like something where it's pretty much out there. A whole bunch of people contribute into it, uh, and everyone else can access it, right? Most of the time it's for free. Sometimes there could be some charge associated with it, and there's different flavors that might be built um, on top of it, or just some variant of this open source software. Uh, so yeah, here they talk about who pays for this technology, how can the company make money if the product is publicly available. Okay, um, so I'll kind of just mention that a little bit. When you look at let's say uh, Linux, right? Linux is an operating system, and it's out there. It's everyone can get their own Linux set up. But then there'll be different people who will come along who will build on top of that, make certain types of enhancements, right? Um, like if you're running a company, right, and you want to use certain types of software, you probably can't just use something that's free right out there that everyone else is using, because you know there are certain assumptions about those type of software, and they only care about certain things. They only care about, let's say, uh, you know, providing a word processor, or you know, Word for you or something like that, Excel sheet or something. But you know, when you're a company, you worry about a number of other different things to make it more, I would say, enterprise friendly. Okay, so you can't really, you could, but you're exposing your company to a lot of risk that way. So usually there's going to be special versions that are built on top of this. You know, you start off with this open source software, but then there'll be some additional belts and braces that are put around it to make it more appropriate, secure, whatever, for a company to use. Okay, so that's why you'll have companies that will come along and make some money by leveraging open source software, right? And there'll be other companies that actually contribute into the open source software, because you know it doesn't really give them a competitive advantage to come up with like some special thing that it's only supportable by them. That means anytime there's an issue with it, there's a bug with it, whatever, they're kind of on the hook to try to fix it, right? But if they get something out there, it's generally working well, other people think it's working well, and they just put it out there into open source, and everybody can get their hands on it, there'll be other people that will enhance it and do whatever with it, and it takes it off of the company's hands so they don't have to worry about it. That's not really their competitive advantage. Their competitive advantage probably is not writing software, or that particular software. It depends which case you're talking about. So that's kind of like how you look at open source software. There'll be some open source software that generally everybody uses. It's almost like a utility or something. Everybody has it out there. But there'll be, and people will contribute to it. They'll make fixes to it. They'll add new features to it, which is great. And then there'll be more commercial versions, which is kind of wrapping up this open source software, which people will sell to make money, which add some additional features that make it more appropriate to run for a particular situation. Most of the time is to run within a company, generally to make it more secure, certain aspects of, let's say, either privacy, personal information, um, potentially like different types of security models that you need to implement that maybe out in the public as a utility, you don't have to worry about it so much. Okay, and that's how certain people might make some money building on top of open source software. They'll come up with their own flavors of that software. Okay. All right, so that's intellectual property with respect to software. Okay, and so the next part, which you probably get more extensive view about this, is talking about copyrights. Okay, so there'll be copyrights. Whether people can make a copy of your work, maybe they can take a copy of your work and make some tweaks to it, uh, uh, redistribute it, essentially make money off of your work. Um, Generally, there'll be copyrights that are supposed to protect the creator of this work. Okay, um, from any number of different angles, either just redistributing it or providing enhancements to it, copying it, uh, maybe taking some flavor of it and changing its meaning, but people can still recognize the work as being something that was originated by, let's say, yourself, that you created something, right? So an example might be, you know, you have Mickey Mouse, right? Like, so Disney obviously owns, uh, you know, between Mickey Mouse and all the other characters for Disney or whatever. If you go out there and you just kind of take everything and then you just kind of tweak one thing, right? Maybe some color or something about it, it's still recognizable. Um, as something, and it's something that you're going to have to go to court if you ever get into that type of situation. Um, so this kind of goes into different categories about what can be copyrighted. Um, so here's the different ideas, facts, you know, what can't be copyrighted. So yeah, so these things are just like, well, okay, quote unquote, okay, the sun is yellow or something like, the sky is blue or something like that. Those are facts. Um, and so there's a certain amount of time where copyrights have expired. So, let's say things from like the early 1900s or something like that. Uh, you know, or classic works, right? Those things will have copyrights that are expired, right? Things that are put out by the U.S. government, laws are not copyright. Um, and then there's the idea of public domain, where I guess in a similar way, it's kind of like open source, right? So they put some ideas out there and they explicitly declare them to be in the public domain. Okay. So intellectual property on the web. So I think it's like what I was saying before, right? So you're making copy of the work. using your work as the foundation or basis for some new work, uh, or just copying it and redistributing it all over the place, um, you know, putting something out into the public, perform the work or display the work. Essentially, like I said, all of these different things would be you benefiting in some way, probably a lot of times benefiting financially from someone else's work. Um, that's what the copyright is supposed to try and cover. Okay, um, so that's how I like to simplify and think about it, right? So anything you can do that you take someone else's work and you profit from it in some way, right? Either making a copy of it, redistributing it, or you taking a copy of it, using it as a basis to do something else, right? Like I gave the example with the Disney character where you just kind of just change the color, but everyone can still recognize it's Mickey Mouse, let's say. Um, so that's kind of what you're looking at with the copyright and what it's trying to protect, okay? Uh, so there's these different categories, um, and I mentioned a little bit earlier in a couple of slides about the public domain. So you can create something just for the enjoyment of everyone. You want to put it on the public domain. You don't really particularly care, to profit from it. So you can declare as public domain. So that's what's down here. Okay. Um, something like this, fair use, this would be something like maybe the materials from the lectures, right? Uh, so it's out there. We're not really out there trying to sell it to make money or anything like that. So it's materials that we put together, but it's out there for educational purpose, let's say. Um, and for personal use, right? That's pretty much exactly what it says, right? You can do it, you can enjoy it, right? But you're not meant to turn around and try to make money from it, right? So, hopefully that's pretty clear. So there's the personal use, there's fair use, and then there's public domain, okay? And this is like what I was saying here. Copyright would expire. Um, like I was saying, the early 1900s. So more specifically, 1923. Uh, you can have basically some access or use to those older materials. I guess they're kind of like classic material, right? So that's considered public domain. Okay. Um, Generally, I guess they're famous or they're well known. So I guess most people, if they would access or use it, they would still recognize the author, whoever originally came up with the work, right? Um, and here's public domain. Okay, this is like stuff that were created by the government, as I mentioned in an earlier slide. Um, and these are facts, right? Um, So, they talk about like, do you need permission, right? Um, so, in some cases, it's just like referring to something and recognizing the ownership or the originator of that intellectual property. Um, so, uh, you can ask for permission and whatnot. Um, I think it's good to play it safe on those type of things. Just to ask for that permission. But a lot of times you can just um, you know make some reference to it depending on what the situation is, right? If in your case you're like using it to, let's say, research for like a book or essay or something like that, uh, that type of content, I think you should just do the recognition of it. Obviously, when it comes to making money from it, that's a different story. Okay. Okay, fair use. This is what I was saying before, just sort of like the educational stuff as an example, right? So this educational or scholarly purpose, right? Um, so I think that was like one of the type of things where I was saying give the example like our lectures or something like that. Uh, you can put some of that out there. And again, I think you should still recognize the originators of the work, but you're not meant to profit from it. Okay. This just kind of talks about some potential consequences if you break copyright law. Okay. Right, and then there's this idea of the Creative Commons license. Um, so, uh, you know, you can share, use, and build on the work that they put out there. Um, so, in some ways, it's almost uh, kind of like open source. So you give the recognition for the author, and then you build on it. Okay, um, so they break down the different categories, right? So this is like giving credit, right? This is what I was talking about before. Give the credit to the originator, um, and this talks about commercial, right? So you're not trying to sell this, um, and derivatives work would be like essentially 99% of the thing is the original thing, and then you just added on something, right? So it's like a subset or a derivative of it. You can tell it's, very much related to the original work. You just added a couple of things to it, right? And um, you know, you can just share it, and use the same commons license, right? Don't change it up into like a more restrictive type of license. Okay. All right. So I think this wraps it up. Um, Let me know if there's any questions about these different types of categories. There's more material about this in the book, so read it up and just understand the definitions for these different categories and how you can use them. Okay, like I said, a lot of times it's just to recognize the originator of the intellectual property, um, assuming that you're not really taking this to try to turn around, sell it, and make money, right? Um, and what public domain is, um, things like this that won't be copyrighted. Those are things that you might be asked about on the exam and stuff like that. And then intellectual property and how that applies to software. Okay, so there's open source software. There's the idea that you're leasing software under the software license agreement. Okay, so these are the key concepts out of this particular lecture. So do try to familiarize with them and let me know if there's any questions. Okay, thank you.